watching humor.
State of Texas, leave Willie alone. The government killed the
Q.
most. Got a problem.
Arthur Burton is a prisoner in Texas. If the state has its way, he'll be dead within the hour. This is Execution Watch. Huntsville, Texas, death penalty capital of the Western world, where prison staff is preparing to put Burton to death by injecting him with a deliberate drug overdose. During the next hour, KPFT's Execution Watch will air live coverage of the killing in Texas, the state that carries out 1/3 of all U.S. executions. Execution Watch host Marlo Blue, criminal defense attorney Merrill Pointier, Huntsville reporter outside the death house Linda Snyder, general reporter Clint Young, and featured interview guest Joseph McCarthy, a polygraph examiner who worked cases with the late great defense attorney and prisoner rights advocate Bill Hapburn. The Execution Watch for Arthur Burton begins.
Q.
Tonight, the state of Texas ushers Arthur Burton into the death chamber. To our listeners around the world, thank you for joining us on this Wednesday, August the 7th, 2024 edition of Execution Watch. I'm Marlo Blue. If you're tuning in for Western World Radio on KPFT Houston, they will be back next week in their regularly scheduled Wednesday 6 o'clock time slot. Execution Watch is produced by a dedicated staff of volunteers. We report live each and every time an execution is scheduled in the state of Texas. The live video stream of this show can be found right now on our Execution Watch Facebook page and simulcast on HoustonMediaSource.org at HMSTV.org. During tonight's broadcast, we will be giving you details about the case, including background surrounding the trial and conviction. We will have expert legal analysis, live reports from Huntsville, guest Joseph McCarthy, owner of Fenian Polygraph Services, and breaking news regarding any last-minute judicial action. Tonight, the state of Texas will execute Arthur Lee Burton. Now age 54, Burton was convicted and sentenced to death for the July 29th, 1997 killing and attempted kidnapping of Nancy Adelman in Houston, Texas. Burton has lost all of his initial and subsequent appeals, and this afternoon, the U.S. Supreme Court rejected Burton's bid for a stay. The execution of Arthur Lee Burton will proceed. Joining us first tonight is our reporter stationed just outside of the death house in Huntsville, Texas, activist Linda Snyder. Hello, Linda. Thank you for joining us.
Hello.
Hello, Linda. Tell us, any news?
The witnesses are crossing the road now in the news media. There's 3 witnesses, but I do not know who they are.
Thank you for that. And to our listeners around the world, please explain why crossing the road makes a difference, what that means.
It means that the execution is going forward.
All right. Please let us know when you learn anything else. How is the atmosphere there tonight?
It's just real quiet. There's just hardly nobody here. And I know he was pretty much a stay by himself man. He didn't really have but one visitor that I ever saw. And I don't know. He just really didn't want to be in the limelight or anything. So he's just very quiet.
Right. Yes, that's what we always hear is that he was extremely quiet. And we will be going into some detail as we proceed today. Well, thanks, Linda. Was he somebody that you would visit? Is he someone that you knew?
No, I did not know him at all.
All right.
We write all of them, but they don't always answer us back. So, we figure they don't want to, have visitors.
Right. I gotcha. I understood. Well, thank you for what you do. Of course, to some of our listeners who may not know Linda, Linda is part of one of the Death Row Angels, and she and Danny are extremely good in their particular, shall we say, ministering to the different people on death row, both the women and the men, I believe. How many people do you actually correspond with at this point, Linda?
Around 50, I guess, I correspond with, but I probably only visit like 30 of them because some of them have families. They just like to hear what news we have, what we found out about cases and things like that.
Right, right. Gotcha. Um, what do you talk about with them before we get into the details of this
We
case? What is your
we talk
correspondence like?
we talk about everything. I mean, they whatever they want to talk about. I don't ever ask them what they did or
Mm,
anything like that because I don't judge and I don't care what they did. I love all of them. I believe in second chances. So
right,
we just talk. We talk about my family, what I do, my animals. They talk about their animals they had when they went in, and about their families, if any of them are still living. So we just talk about everything.
right. The comforting things. I see.
Yes.
To our listeners too, I'd like to explain that Huntsville is, although very close to Houston, where we are located for KPFT and for Houston Media Source, it is a bit of a stretch to get there, and many of our activists and people who are involved in this show do not live in Houston, and we appreciate all of the effort that they make to put this show together every week. Linda, please let us know when they come out.
I will. Thank you.
Thank you. So let's go to our panel. Let's turn to our panel now and get some feedback on some of the different aspects of this case. Joining us tonight are criminal defense attorney Meryl Pontier and Execution Watch reporter Clinton Young, a former death row inmate himself. Welcome. So, Meryl, can you explain this case to us?
Yeah, sure. I will start at the trial level and we'll discuss the state habeas, federal habeas, and a Supreme Court. So Arthur Burton was convicted and sentenced to death for a murder and attempted rape of 48-year-old Nancy Edelman in Houston on July 28, 1997. On that day, Miss Adelman left her home at around 7 p.m. to take a run along the bayou that was close to her house. She never made it home. The next day, her body was found in a 4 feet hole in a heavily wooded area close to her house. She was, according to court records, she was beaten and her shorts and underwear had been removed. Witnesses reported that they saw a dirty and angry looking man riding a bike around the time that Miss Adelman was taking a run at that wooded area. Using the description that witnesses provided, the police released a composite sketch to the public, and some individuals pointed out that they recognized Arthur Burton, and so the police took him into custody for questions 10 days later. He initially denied the murder, but when the police confronted him with inconsistencies in his story, according to court records, he confessed. He signed a confession, and that confession said that he took Miss Adelman, or he dragged her into the woods, choked her, and removed her shorts and underwear and attempted to rape her. I believe the confession said he did not actually rape her. That statement further said that when Miss Adelman regained her consciousness, she started screaming. And so Arthur Burton choked her unconscious and dragged her into a hole. The statement further describes that he was at that point ready to leave the scene, but he saw a person walking nearby, and so according to that statement, he walked back to the hole and tied her up with her shoelace, strangled her. At the trial, the state based its case on eyewitnesses who described that seeing Burton near the crime scene, and they based it on his own confession that he signed. The defense, they placed doubts on those identifications, and also placed doubts on that confession, saying that he only confessed after abuse by the police. Nonetheless, Burton was convicted of murder, sentenced to death. However, on direct appeal, that death sentence was overturned by the CCA. and he was given a second punishment hearing in 2002. During that hearing, the state presented evidence of burglaries, evidence that Burton supposedly sold drugs, and also evidence of a prison classification interview whenever Burton first entered death row, where he had said supposedly that he killed the victim. And according to that statement, it was something that he just couldn't help. This became a big part of the litigation later on, this supposed statement that he made. The defense presented evidence of his childhood that was full of poverty, and also said he was remorseful for his crimes. However, he got another death sentence in 2002. In state post-conviction, he filed a first writ application stating that he was innocent of his crime. That was denied in 2006. He filed a second writ application in 2003, stating that he received ineffective assistance of counsel during that second punishment phase because his trial counsel did not object to the admission of the statement he allegedly made during the classification interview in prison. The CCA actually sent the case back to the trial court because of that in 2007. Burton said it was a custodial interrogation, and so that statement could not come in to evidence. And he said his trial counsel should have objected. The CCA, however, denied all relief. They said that at the time, the issue of this being a custodial statement or not was unsettled. And also, that's why the trial attorneys were not at fault for not objecting to the admission of that statement. He went into federal post-conviction. Again, made the argument that that statement during the classification interview should not have come in, and it was a violation of his Fifth Amendment right to self-incrimination. He also again argued ineffective assistance of counsel for his attorneys not objecting to it. And he also made a claim of actual innocence, saying that he was coerced into confessing this crime. The federal district court said that the innocence claim was unpersuasive and denied all relief in 2012. And then again, another writ application was filed in July this year. His attorney stated that Mr. Burton was intellectually disabled and that therefore he should not be executed. He also made the same claim with the U.S. Supreme Court, and both of those claims were denied.
I'd like to talk a little bit about the claim of intellectual disability, because that does seem to be a constant theme throughout Mr. Burton's existence, especially while incarcerated. I would like to talk specifically about, let's go ahead on the last Supreme Court petition for a writ of certiorari to the Texas Court of Criminal Appeals. Burton's attorneys brought up the Atkins claim. What is that under Texas law?
So Atkins versus Virginia is a Supreme Court case where the Supreme Court decided that people who have an intellectual disability cannot be executed because they cannot really comprehend the sentence that they received for their crime. And so the Supreme Court said, we're not going to execute people who are intellectually disabled. They cannot understand basically why they're being executed. And so that is the case that Arthur used to argue that he could not be executed.
I'd like to read something from an inmate who's over on death row right now, Tony Abuna Ford. He said regarding Arthur Burton, he said they call him Bird. We'll go into that in a little bit too. Bird functioned at a level to where he needed to be helped understanding what for most of us would be basic things. He had an Atkins issue, and then he goes on to explain that to those not familiar with what an Atkins issue is, it's an issue that marks you mildly for extremely mentally retarded. One thing that those of us who knew Bird that we've wondered about is if he was on the autism spectrum. If it's that noticeable, why would the state of Texas not pay attention to that type of claim? And why did they not in this particular instance?
Well, intellectual disability is not always noticeable. You need a certain IQ score, and it's not a straight cutoff, but in practice, it's about IQ of about 70. It could be a little bit higher, could be a little bit lower. It's not a straight cutoff, but an IQ of 70 indicates an intellectual disability. And then you need adaptive deficits. So your behavior kind of needs to match that low IQ. Because if you complete, let's say, college degree, you have an IQ of 70, that doesn't match your IQ. So your behavior needs to match the IQ. That's adaptive deficits. And all of that needs to appear before the age of 18. And so in this case, Atkins was a Supreme Court case from 2002. Arthur Burton his first writ application was filed in 2003. At that time, he did not make this claim. And he should have made that claim in 2003, and he didn't. So now, 20 years later, he cannot make that claim because he had the opportunity to file it 20 years ago and he didn't. And so that's the problem there.
A legal snafu. All right, I understand that. What do you think about the way this case was handled? Can you give us any insight into how things could have been different?
Well, the thing I noticed was that he filed those two writ applications in 2003, and then nothing was filed for 20 years, and then the third writ application was filed in July this year. And so I don't know if he had a change of attorneys. He may have had change of attorney several times. He did go to federal court, so there's that in 2012. But then we see nothing happening for a long time. And maybe Cleanza can comment on that too, but that might be a little bit uncommon to not have any action in a death penalty case for so long. That's what I noticed.
Right, that's a long time. That's what, 21 years. I mean, it's crazy. Clinton, let's bring you in now, if you don't mind. We've got Clinton Young as one of our participants today. Hi, Clinton.
Hey, how's it going?
Very good, thank you. Tell us, you knew Bird. Tell us a little bit about him, if you can.
I mean, I agree with what Abuno said. I mean, he was quiet. He'd go to rec sometimes. We weren't never friends or really associated or anything like that. Like, I couldn't even remember if I even lived on the same section with him. I mean, I've been on a pod with him several times. But yeah, like, I mean, Abuno said everything, right? And so, that was his I mean, that was like part of his reputation, right? That he was slow, right? And so, given how they've handed out the Atkins claim in certain cases, oh, I won't say anything on that, but I'll just say this: that I believe that he would have qualified for it. But as Merrill said, his attorneys waited too long to bring it up. And so, you know, this is the problem with the court sitting there saying that if a lawyer fails to do something, the defendant is held responsible for it. All right, this is a prime example. Here it is, you have somebody that's intellectually disabled. It doesn't have the comprehension skills to really grasp the law, what needs to be done, and et cetera. And there might be insecurities in that, like, so he doesn't really want to talk about the law with other people because he doesn't understand it. So it's easier to talk about, like, what are the Cowboys or the Texans doing, you know, or things like that, or commissary. And so he never really gets the opportunity to learn the law and doesn't know to tell his attorneys, hey, y'all need to raise this issue. Like, most people that are intellectually disabled from being in prison, they don't understand they're intellectually disabled. You know what I'm saying? Because there's a lot of intellectually disabled people down there that think they're geniuses. But
right.
Bird wasn't that type. No, I said that to make people laugh, but Bird wasn't that type. So here it is, he didn't have the wherewithal to be able to adequately communicate with his attorneys, and his attorneys failed to do their job. They should have brought it up. Atkins was decided in 2002. They should have brought it up in 2003 in a writ that was filed. Everybody had an opportunity. They had so much time after Atkins was decided to file it in federal court, if they was in federal court, and asked to go back to state court or file it in state court, and etc. And that wasn't done, and he's getting executed tonight when he otherwise could have gotten relief.
Meryl, do you know by any chance if he had a public defender?
I would assume so. I think most people on death row had public defenders, and this was a case from 1997, 1998. I don't think anyone could afford an attorney, especially in a capital murder trial.
We often talk about how expensive a capital murder trial is versus how expensive it is to keep an inmate in prison until an execution date. Does anyone have any idea how much it might actually be at this point in time for just to go to trial for a capital murder? No? Okay. Well, we'll get
Well,
back
it depends. I mean, it depends on the case. It depends on, how many murders. It depends on the county. I've read articles on this where it was said it would cost about $1 million to have a death penalty trial. But it is generally accepted that it costs way more to have a death penalty trial, to have all the post-conviction litigation, to keep somebody in solitary confinement for 10, 15, 20 years, to then execute somebody, than it would cost to give that person a life sentence and let them stay in general population for the rest of their lives. It costs more to have a death sentence and a trial and all the litigation after that.
Clinton, you've experienced solitary confinement versus, were you ever in general population? I don't know.
In the county jail and
Yeah.
juvenile prison.
Can you
But
explain
not
the differences?
Yeah, there's a big deal. I mean, you get to go to the chow hall, you get to go to commissary, and get your various commissary items. You can walk, depending on your custody level, you can walk without handcuffs. Because there's different custody levels in general population. If you're a G5, for example, well, they don't really call close custody. They call it close custody for a reason. I'll take that back. But if you're G1, G2, for example, you can move around more freely. You can have access to better jobs. You can have contact visits with your family, etc. Whereas on death row, you have to be stripped out when you come out of your cell. You have to be handcuffed behind your back. You have to be escorted by 2 officers. If they're short of staff, and you got to sit there and wait. And so they get there, and your visitors often have to sit there at visitation waiting on you, sometimes up to 2 hours. Because, I mean, you're at the mercy of the staff. They bring you your food. Right. They bring you your commissary. You have to wait on them to come get you, to take you to sick hall. They bring you your library books. You have to fill out a little slip and turn it in. You can't go to the library and actually look at the books on the shelf and see if, okay, this copy's damaged, for example, because some individual felt the need to tear out the last page. And, you get the book. You're at the mercy of the officer that brings you the book, which that was another pet peeve of mine. But right. So you're totally at the mercy. The best example I always tell everybody was one time they shut off the water, and the water was shut off all day because they had to work on some pipes. And I was sitting in the cell, and I was like, I came to the door. I said, man, I don't even have the liberty to flush my toilet right now if I want to. I have to wait on them to turn the water back on, and it's a long process when they shut it off for the whole unit.
Sure.
And so it's just you're in a state of total dependence on other people. You're by yourself, right? There's nothing fun about it, at least for me, right?
Let me bring in Linda Snyder right now. Linda, I'm hoping that you're listening to us. We've just brought up something that we've never mentioned before, and I think people would be interested in, and that is the process of how visitation works. Can you tell us a little bit about that?
Yes, you have to, now we have to make visits, for death row inmates. We have to call like on Monday if we want to see them on Thursday. We want to see them on Tuesday, we have to call on the Thursday before Tuesday comes. And then after that, if you want to see them on Saturday night, you have to call by noon on Wednesday. And of course, GP is different. You know, you have a portal that you can make your visits on GP and pick out the time frame that you want. But everything on death row, you have to call in and they have to tell you what openings they have.
And then you get a time allotted to you that you can show up in Livingston. Is that correct? Or
A 2-hour time, yes. 2-hour
is it the
limit,
same
or if
thing?
you're coming from overseas, 4 hours.
And of course, these are non-contact visits.
Yes, nothing. You don't ever get to see the inmate except after he's executed and he's laying on the gurney at the church. That's when the mothers can finally hug their sons. It's sad.
That was the hardest part for me, was not being able to hug my baby sister, my nephews,
Mhm.
you know, basically
Yes.
watching my baby sister grow up through glass.
Right. Right.
It
Absolutely.
hurts us to see the children see their daddies behind the glass, and they're like, "Daddy, can I sit on your lap? Daddy, can I kiss you?" But they can't, and it's hard for children to understand that.
Right. Right. Understood. You've been visiting death row inmates for a long time now. How did you get started?
My husband's brother-in-law was on death row in 2005, but he's now since got
She's
moved
gonna
to
have to
life.
work. Okay.
So he's at the Robinson unit now.
Is there any change in what's happening there in front of the death house?
They have not come out yet. No.
All right, thank you. Well, let's move on a little bit. We do have a guest tonight. While we await, I guess, let me just say a couple of more things in this letter from Ibuna, which I'm very pleased to have received. He says that Arthur Burton was a quiet person. Excuse me, he's never raised his voice at any time. Many times you'd forget he was even in the section or even a neighbor because he was so quiet. Bird didn't do anything that would cause attention to himself in ways that other people would out there on the row if he was upset or didn't get his way. To many back here, Bird was cool. To me and a few others, he is a brother. One of the things that would strike you about Bird upon first looking at him is the fact that he was so skinny. Despite his build, he could run with the best in games of run and shoot, and our exercise, many guys who were bigger and more muscular defined. But you have many people that are back there like that. He also goes on to talk about Bird being a gamer and the joy that that would bring. He one more thing, he says, only to see years ago when he received a new punishment phase, I thought he would finally leave this hell, only to see Bird back here on the row a few cells down from me. Did being back here weigh on his mind? Could he fully understand what it means to be here on death row in the same way that I or someone else without an Atkins issue can? I don't know. What I do know is that the CCA refused to hear his appeal without consideration of the merits. I spoke with Arthur Burton with Bird early this morning before he was taken out of here, possibly for the last time. He was not bitter, but he wondered, like I wonder, how this madness could still be happening. He knew that Texas wanted to do him in. The why of it, well, that's another matter. Something, again, that the CCA refused to find out with another Atkins appeal that was set before them. Always in strength and in spirit, Tony Ibuna Ford. If you are listening from overseas, these are very strong words that prisoners, inmates receive, but they care so much about each other, and they do seem to make a difference. Clinton, before we go on to the next segment, I would like to know, do you still keep in touch with anybody on the row?
Can you hear me? Am I muted?
Yes. No, you're not
Oh,
muted.
you hear me? Okay. You said yes. I was like, oh, but oh yeah. Surely I do, right? I have to straighten this up because my cell phone holder's not gripping. But
Gotcha.
yeah, I still keep in touch with people, right? I wanted to go back down there and visit some people, especially after being out 2 years, but it made its way all the way up to Brian Collier, and Brian Collier said that Clinton Young will not enter his prison system ever again. So
And
he won't let me.
And who is Brian Collier?
The executive director of TDCJ.
Thank you.
Yeah,
All
he.
right, well,
I can write people and I can
you
talk
need
to
better
people on the
friends,
phone.
Clinton. Yeah, there you
No,
go.
it just how I was down there, right? And,
Gotcha.
they say I
It's
know too much, whatever that means.
we'll talk about that later. Let's begin with our interview while we wait to find out the finality of what is happening in Huntsville, Texas. Our guest tonight is Joseph McCarthy. He's a licensed polygraph examiner and owner of Finney and Polygraph Services in Dallas. He worked a number of cases with Bill Hepburn, the late criminal defense lawyer, famous for his lifelong dedication to the rights of inmates and parolees. Welcome so much. I appreciate it, Mr. McCarthy. Talk to us, please. What is a polygraph, using terms that we can all understand?
Well, first of all, I'd like to hope that Bill is listening or watching from somewhere. You are missed.
Yes.
What is polygraph? Let me go ahead and simple it down for everybody, because I could use fancy words like salience or cognitive pull. All that means nothing. Basically, the simplest explanation is polygraph works on a basis of fear. That's one of the theories of polygraph. The question that you are the most afraid of is the question that you will psychologically and physiologically react to the most. So it's not really a lie detector test. It's more of a fear detector test.
A fear detector test. And what kind of tells do you look for?
Well, I mean, in the pre-test interview, I am looking for certain tells. Some of those tells are actually what I like to call helpful tells, because we're not just willy-nilly looking for reaction. We're looking for reaction at specific places, at specific times, and the reactions have to be significant beyond some of the others. One of those questions is called a control question. I'm not giving away any secrets. There's no, cards up my sleeve or anything like that. What I want to do is I want a baseline of what to look for. So I'm going to go ahead and institute a control question. Like, for instance, while you were in school, in a case like a murder case, while you were in school, have you ever thought about killing somebody? Okay. I'm trying to get that baseline of fear. Okay. Because everybody in school has thought, I'd really like to knock that kid out. What I'm doing there is I'm making sure that I get a strong enough control question to compare against such a strong question, relevant question of, did you cause that person's death? Did you shoot that person? Did you stab that person? I mean, you need one heck of a control question to get past that, because somebody who's accused of a crime like that is already afraid. They're already petrified of what's going on. So on one level, you got to calm that fear down, and you got to direct that fear into a control question. Now, if the person did it, well, you can help them out all you want. It's not going to help. But to the innocent person, you do got to go ahead and you got to institute that really strong control question, and you got to find out where the button is, and then you got to press it over and over again like Bart Simpson. And that's a tough thing to do. In other cases, it's way easier, but in a murder case, it's very difficult to do.
Um, People sometimes call a polygraph a lie detector test. Is that term accurate or is it a misnomer?
Ugh. Oh, I hate that term. Uh, there is no such thing as a lie detector machine. Again, that's not what this instrument does. The instrument measures your physiological reactions to your mental state of mind. Again, we're measuring a fear response, okay? And where that response comes from in the human mind and in the human body is called the sympathetic nervous system, which is attached to the autonomic nervous system. Autonomic nervous system meaning everything is running automatically. Heart, lung, glands, everything that works without us needing to think about it. Then from the autonomic, the reaction moves to the sympathetic, where we see the reaction. Okay, that fear reaction. There are three things that the polygraph that part of the nervous system measures: fear, surprise, and acute pain. Which is why there's no such thing as a surprise question on a polygraph. I don't care how many times you've seen Meet the Parents; it doesn't happen like that. Okay, and I look nothing like Robert De Niro. I'm way better looking than that guy is. Okay, so that takes care of surprise. Fear, that's what we're looking for. Surprise, again, we're not trying to trick you. And pain. If you're in any type of acute pain, if you've got severe back problems, that's documented. You're going through a cancer treatment. Those people are not qualified to take a polygraph.
Um, Joe, could you talk a little bit about the admissibility of polygraph results in a trial?
Well, there's a lot of controversy about that, and I can understand the controversy. My personal opinion, I don't think a polygraph should be admissible in trial. That's not what this instrument does. And next thing you know, if it's admissible in trial, somebody gets a bad polygraph, jury's going to sit there and say, you know what, send him up the river. He failed the polygraph. That's not what our trial system's supposed to be about. It's supposed to be about the totality of the evidence. I think that if the polygraph was admissible at trial, I think it would make a jury very lazy. For the most part, it's not admissible in a criminal trial. The burden of proof is simply just too high, and I don't think it should ever be admissible in trial because of that burden of proof.
Let me ask you another question.
Sure.
What about non-trial situations with looser rules of evidence? For example, couldn't polygraph results be used in the punishment phase of a capital trial as mitigating evidence?
Well, that was actually a really good question. And I went to my legal department, AKA my wife. She's a practicing attorney here in Texas. Very, very beautiful woman. I love you. Uh, according to her, it's the rules of evidence are the same in punishment as they are in trial. So as far as I know, which is what she tells me, no, it's not admissible as mitigating evidence during punishment phase. However, polygraph is admissible, let's say at the grand jury level. Any type of felony offense goes to the grand jury, and that would be the time to go ahead and get that polygraph is before that grand jury, because that grand jury can look at that polygraph and say, well, golly gee whiz, he passed a polygraph about it. Some of the evidence seems a little shady. We're going to go ahead and no bill. By the same token, works the other way. If you're taking a polygraph that is police and DA sponsored, and you fail that polygraph helps that DA get a true bill on you. So it goes both ways, but we got to remember, it's easy for a DA to get a true bill. Okay, there's an old saying: you can indict a ham sandwich in a wheelchair. And I don't know what the ham sandwich is doing in the wheelchair, and I hope it feels better. But by the same token, you want to go ahead and you want to make sure that if you didn't do this, that you get a fair, independent, and most of all, and this is the biggest point, and it's part of our mantra here at Finney and Polygraph Services: fair, independent, and unbiased polygraph examination.
What do you think about attempts to introduce the results of functional MRI tests as evidence of truthfulness?
Well, there's a couple of issues with that. The biggest issue being time. You got to send that MRI out to be examined and analyzed. From a law enforcement standpoint or from an interrogation standpoint, then you got to take a break between the test itself and further interview. That can act as a cooling period and actually make it more difficult to get an interrogation, assuming that you have a fair interrogator in front of you. There's a lot of studies that's going on about it. Some of the studies say good things, some of the studies say bad things, but I have no professional opinion about it yet because I haven't seen anything that, okay, this works as good as polygraph, let's go ahead and switch things out. Now, there's another form of lie detection or deception and that's called eye detect. And basically, you're putting your head in a mount and a camera's taking pictures of your pupils and the dilation and everything of the eyes. And there's a lot of issues about the reliability and accuracy of that I'm not going to get into because, well, I don't know. I've never done an eye detect examination. So there's that.
Is anyone actually using that MRI method?
Not that I know of. I
Right.
haven't heard of it in Texas yet.
And just to clarify, you're saying that something like this eye detect method would really depend on someone's chemicals or someone's fear reaction as well as anything
Ultimately,
else that's going on in their brain?
from what I know, it works on basically the same principle of, depending on the school of thought you come from in polygraph, psychological set, cognitive pull, salience, all kinds of fancy words that say everything but really mean nothing.
Okay, I've got one more question, and then I'm going to throw it to Meryl and to Clinton to ask you
All right.
what's on their mind. For people who are on death row, who are appealing their sentences, what's the most important point for them to bear in mind about polygraph exams?
Fair, independent, and unbiased. You want to make sure that you have a private polygraph examiner. You want to make sure that the polygraph examiner is American Polygraph Association trained. You want to make sure that polygraph examiner belongs to a professional organization, such as the professional organization I belong to, the National Polygraph Association. They're wonderful people there. You want to make sure that polygraph examiner has quite a degree of experience and will talk with you and not at you. I think that the polygraph examiner's attitude means so much coming into the test and leaving the test. There are some polygraph examiners, they have two speeds, stop and go. I'm personally not like that. I go through all the gears and I start the polygraph examination with a handshake. I ask people if they want to be called by their first name or as Mr. or Mrs. So-and-so, because I think that's a level of respect that everybody deserves. And that's something I have a reputation for. You want to make sure that the polygraph examiner is going to hold up and is going to stand firm on the results of their test. There are just so many things to look into in a case where there's so much to win or lose. I could go on forever about what you got to be careful of and what you got to watch for.
How is there a rating system for people in your line of work? How would people know what someone's reputation is? Where would they go?
Well, the first thing you do is you make some phone calls around, and the best places to make phone calls around are other defense attorneys.
Right.
Other defense attorneys, they know the polygraph examiners out there that aren't going to set you up for failure. They know the polygraph examiners out there that have good personalities that's conducive to a fair test. Though that would be the first step I would do is, if I were a defense attorney representing somebody like that, I'd be asking around the courthouse. They're also, you got to do your research online, make sure, again, they're part of a good polygraph association, that they've been licensed in the past. Quick note here in Texas, there is no more licensing requirements for polygraph examiners. They repealed the Polygraph Examiners Act here in Texas, which means anybody could be any one of you could buy a polygraph machine today and be in business tomorrow. That's one of the reasons why, when that happened, I went up to Oklahoma and got my polygraph examiner's license in Oklahoma, because now I still have a polygraph examiner's license. I'm still accountable to rules, regulations, proper procedures, proper standards. Okay. Probation departments might be another good place for a defense attorney to call, or if they know other probation officers, because polygraphs are used in certain probation cases. Ask them, hey, who's got a great personality? Who's got a good polygraph? Who's got a reputation for being fair, independent, and unbiased? One big pet peeve I have, though, is polygraph examiners with high inconclusive rates. And that's very easy to find out about by, well, again, just asking around. Unfortunately, there's no such thing as a rating system from 1 to 10. Oh, this polygraph examiner's a 10, this polygraph examiner's a 0. Probably because it's a little bit too subjective. One person's polygraph isn't the same as the other. Some people might, I've had some people that have called me mean, but most people say I'm one of the nicest polygraph examiners in the area. It's all subjective. So ask around. Make sure that polygraph examiner has a low inconclusive rate. There's one firm in Texas that has a 45% inconclusive rate. Why would you want to go to that guy? Doesn't make sense. You gotta do your.
Let me bring in Meryl at this point. Meryl, have you ever used a polygraph expert in a polygraph examiner in any of your cases?
I have not, no. And for the reason that you cannot bring it in as evidence. And even the Supreme Court said, the scientific community is too divided on whether or not this is reliable. And so I don't know if I would want my innocent client doing a polygraph, because I don't know what the risk is of getting a false positive, for example.
Well, the risk is null if you're the one that's asking for the polygraph, because it's attorney-client work product.
Yeah, but the test might show deceptive when it's not.
Well, and that is, that is a problem. I'm not going to lie. There are times when a test could go wrong for whatever reason or another, and there are about a billion. There are lots of reasons why somebody would come up with a false deception indicated. And that I guess that's where the crux of the whole thing comes from. I'm not one of those polygraph examiners that is, bows to the almighty people that say polygraph is so perfect, because only God is perfect. Some people even come up with false non-deception indicators. False positives and false negatives are a factual thing. They happen, and to deny it happens, well, is to be in denial. And that's a place that nobody wants to be in, because the worst kind of lie in the world is the lie you tell to yourself.
You are listening to Execution Watch here on KPFT 90.1 FM and on Houston Media Source TV simulcast. We are talking to our panel. Let me just check in quickly, please, with Miss Linda Snyder. Linda, have you heard any word? Okay, we have not. She'll be back with us.
I think Linda fell off.
Okay. All right. So we are still looking to see if the witnesses have come back from across the road and to find out if the finality of Mr. Arthur Burton's life has come to its close. Clinton, do you have any? Oh, I'm sorry.
There
Linda?
she is.
Hey, Linda.
Yeah, my phone got too hot. They won't let us get under the shade. We have to stand in the sun, and it's 105 degrees.
Yeah.
And my phone went out.
I understand. Technology was not made for the Texas heat. That's absolutely sure. I hope you're in your air-conditioned car at this point.
I am. And it was 6:21. It was 6:21 when the family came back across.
Thank you. Thank you so much, Linda. We appreciate you doing this for us. We really do. And
Thank
so ends the life of Mr. Arthur Burton. Rest in peace, Arthur.
Yeah, let me say this, Marlo, real quick. Because when Merrill was summarizing the state's theory of the case, it said it like he had his confession. Well, unless I'm mistaken, they can't convict on confession alone because a lot of confessions are not foolproof and have been, there's people that have given false confessions and etc. And an eyewitness statement, well, a witness has described somebody in the area, etc. It seemed like there was no DNA in the case and things like that. And so the police department in Houston, Texas, hold on, what's happening here? Okay. But the police department in Houston, Texas at the time was notoriously known for the tactics that they used. And sorry, I'm on a bumpy road. They there's a guy on death row.
The Linda Price's number. He erased our phone.
What? Oh, it's Linda.
I'm sorry.
But there's a guy on death row where they basically Charles Robbie, they held his girlfriend hostage, for example. On and on and on. And so in cases like this where you have somebody mute Linda, Mark. In cases, especially you have like the Atkins claim, for example, how easy would it be for the police to manipulate them, to get them to say things based on their interpretation of the crime scene and etc. This is why it's so important that you have good lawyers, or people that invoke their Fifth Amendment right, and that lawyers at the early stages of cases do what they're ethically bound to do. Dole Lane, he was on death row, and supposedly they gave him cookies to get him to confess. Somebody who's intellectually disabled would be faster to submit their rights versus then stand up and enforce their rights. So that's just, like I said, something I wanted to touch on, right? That given the fact that Bird had the mental capacity that he did, and it seemed like his whole case hung on this confession, which he said later on was a result of police brutality, which was that was the MO for Harris County Sheriff's Office and Houston Police Department back in the 90s and early 2000s.
I've got to say something to add on to Clinton, because not only am I a professional polygraph examiner, as a polygraph examiner, I have a lot of interrogation training. I am Reed School Advanced trained in interrogation. It is relatively easy, given a mental disability, to go ahead and get. I mean, some of these guys, I could get them to confess to killing JFK if I really wanted to. All you got to do is twist them enough. When you got a case, I think, that has an interrogation, a polygraph examiner is a perfect person to hire as a second look at that interrogation, if that interrogation was audio and video recorded, because you want to make sure that interrogation was done correctly. You want to take a look at how long was that person under interrogation, because there are some people, the minute that you you leave them there for too long, and they will tell you whatever you want to hear to end the interrogation. So that's something that most lawyers want to look at when you got something like that.
Yeah, I mean, that makes sense, right? My co-defendant failed a polygraph exam, and they asked him, she told him that he failed, he didn't protest. His response was, "Oh, I know what it is." Yeah, I do too. But yeah, I mean, it's bad, right? Like, especially Jerry Garino, Jerome Govich. I mean, you had all these attorneys in Houston back then that was taking death penalty cases. And the police tactics given in the 80s and 90s. Well, I'll just use modern term, 90s and early 2000s. And we all know how Chuck Rosenthal's administration was. There's too many opportunities to get it wrong in cases like this, where if you get it wrong, nobody can bring Bird back.
Right.
You know, I wasn't there. I don't know if he done it. It does. I mean, I'm never going to say, I'm never going to say anybody's guilty one way or another, of course, but it's just kind of bothersome that, like, I mean, you have an intellectually disabled person and you have this supposed confession, which he alleges is under duress, and that's it. I mean, there's people saying that, they seen an angry looking skinny black man in the area. Okay, well, how many angry, skinny black guys walked around that area that day? You know? So yeah, that's what I'm saying, man. That's the problem with the death penalty right there is, if they get it wrong, there's no way to make it right. And as far as the prison psychiatrist, whatever, right? I mean, I ain't gonna believe nothing that ever comes from anybody in TDCJ, period.
Well, we're getting ready to close. So any final words, Meryl?
Well, I agree. And the sad thing is the death penalty, it's been 26 years since the victim died, and this case would have been handled differently today with what we know about potentially false confessions, what we know about intellectual disability, what we know about eyewitness identifications. We've advanced a lot in the last 26 years. The case law's advanced a lot. Attorneys have gotten better. There's more protection for defendants, more due process, more rights. And so this case would have been handled differently if he was tried today versus 26 years ago.
Thank you. Thank you. Thanks, everyone. That brings to a close this edition of Execution Watch. Our next scheduled broadcast date is Thursday, is in September, as Texas prepares to end Travis Mullis into the death chamber in Huntsville. Execution Watch will cover the state-sanctioned killing beginning at 6 p.m. Central Time with our live news coverage. We welcome your opinions on social media and beyond. Go to executionwatch.org to learn more about the death penalty and to join our mailing list. Our thanks again to the entire Execution Watch crew, legal analyst Meryl Pontier, reporters Linda Snyder and Clinton Young, video director Mark Pirtle, technical director Otis McClay, engineer Howard Reynolds, board op Basil Coleman, social media Elise Bench, executive producer, as always, Elizabeth Anstein. If you're listening live on 90.1 FM, stay tuned for Living Art. This has been Execution Watch. I'm Marlo Blue. Good night.
State of Texas, leave Willie alone. The government killed our most. Got a problem, death row. Ever wonder where money goes? People of Texas, don't you know? Some accused are innocent. Some get good lawyers, most don't. State of Texas, killing machine. Don't you know they're killing people?